So today's, welcome first of all to the webinar on understanding contractual terms and avoiding disputes. I'm Kala from Telso Procurement, and this is on behalf of procurementexpress.com. Rob alluded to the fact that contractual terms is a struggle for it to be interesting. But I guess if you are involved with contracts between buyer and supplier, then it certainly will be of interest, because potentially you can either increase your risk in a business transaction, or you can reduce your risk and save costs as well. So that's the purpose of today's webinar, to have a bit more understanding about the nature of contracts, what to look out for, and how we can reduce the amount of risk involved in business with suppliers, or vice versa, and the costs involved as well. Okay, so I think the first place to start is what is a contract. So a contract is a legally binding promise. Now, contracts can be written or oral by one party to fulfill an obligation to another in return for consideration. So I think the key thing, a number of things there. First of all, it can be written or oral. There is such a thing as an oral contract. Also, I think it's worth considering that contracts are whatever the two parties agree, so long as whatever they're agreeing about is legal. Whatever two parties agree is the contract. So it's very important from a negotiation point of view, you make sure that your interests are correctly outlined in the contract, so that your interests are protected throughout the business relationship or transaction. In terms of a contract, like I said, it can be oral or written, but there are 5 elements that must exist in a contract for it to be considered a contract, whether it's a written contract or whether it's an oral contract. The first is an offer. So there must be an offer made. In other words, one party must promise the other party to, provide a service or a product in return for, money or some form of value. Right, so that's an offer. So, for example, I can offer to sell you a pen for $10, and that's an offer, right? I've offered to sell you a pen in return for $10. You, with that offer, can either accept my offer, and if you accept my offer, you must accept my offer in full. If you decide that yes, you want the pen, but you don't want to pay $10, you want to pay $8, that is not an acceptance, right? Actually, what you're doing is counter offering back. So you would be counter offering me back, saying, yeah, I want the pen, but I'd like to pay $8 instead of 10. And then it will be left for me to either accept $8 in full, as you promised, or as you've offered it to me, or I could counter offer back and say, no, I'd like it to be $9, for example. And potentially you can get a counter offer going back and forth until one party accepts the total offer from the other party. Another element of a contract is consideration. So in a contract, both parties must gain something from the contract and lose something from the contract. And when I say something, I mean something of value. So again, using the example I've just given, if I offer to sell a pen for $10, I am losing a pen, but gaining $10. And you that's buying the pen are losing $10, but gaining a pen. So there's an exchange of value. Now, obviously, the value doesn't always need to be money, but it needs to have monetary value. Another thing as well, the value doesn't need to be fair. So if I said that I was selling you a Ferrari for £1 and you agreed, the fact that the Ferrari cost $250,000 is irrelevant. What the court will look at is that, value has changed hands, right? £1 has gone in one direction, a Ferrari has gone in another direction. Another element is legal relations. So there must be an intention for both parties to be legally bound. And in the event that one party doesn't meet their obligation, there's an expectation that it will go to court, or it could go to court, and a judge will decide upon the dispute. And finally, capacity. Now, capacity refers to the fact that both parties must be of legal age. Both parties should be of correct authority to enter into the contract, and also, whoever's signing the contract must be, should I say, of sound mind, and not be under the influence of any alcohol or anything like that. And the reason I mention alcohol is because there was a case that of Sports Direct. Now, if you don't know, if you've not heard of Sports Direct is a sports retailer. They sell sports apparel and sportswear, and they are a multi-billion pound company in the UK and across Europe. Their chairman and owner is a chap called Mike Ashley, and he's a colourful character, and he tends to have his board meetings in pubs or in bars. And in one such board meeting, he promised his finance director, after having, consuming alcohol, allegedly, he promised his finance director that if the share price went up to £8, he would pay his finance director £15 million in return. And guess what? The share price went up to £8, and the finance director said to the chairman, you remember when we were in the bar or the pub the other day, you said that if the share price went up, you'd pay me £15 million. And it has gone up to £8, so pay me £15 million. Mike Ashley, the chairman, said, look, we were drinking, we were having some fun. I just, said something, I wasn't being serious. Well, the finance director took it serious to the extent that it ended up in court. And the court, or shall I say the judge, found that because it was successfully argued that Mike Ashley was in a social area, consuming alcohol and so on, that he lacked the capacity to enter into a contract and therefore could not be bound by the promise he made. Right. So ultimately, the finance director did not get the £15 million he thought, or she thought they might get. So what this shows, I guess, is that if you're gonna sign a contract, make sure no one's under the influence. Standard terms and conditions. I'm sure all your organizations have your own set standard terms and conditions. I think it's also important to note that the vendors or the suppliers also have their terms and conditions. And terms and conditions are a useful one-size-fits-all set of T's and C's that allow you to carry out or contract routine items, goods and services that you buy in the daily course of your business without having to draft a new contract each time. Yeah, so you can use this one-size-fits-all terms and conditions, which covers most of the routine items that you buy in your daily course of business, right? So the benefits of that is that it saves time and it's consistent, right? I think something to remember as well is that when you are using your company's standard terms and conditions, whilst they're suitable for a lot of routine purchases that you normally carry out, they may not be suitable for all purchases. So it's important to be able to recognize if your terms and conditions do not cover a certain machine or certain service that you're buying. And if that's the case, you need to, create a separate contract that covers it. If you, use your standard terms for a non-routine item, potentially there are going to be gaps in terms of what you're covered for. And then you may be putting yourself at additional risk. So just make sure that any goods and services you're buying are adequately covered under the terms and conditions. If they're not, then you need to draft a new agreement or new contract, I should say. Battle of the forms. Now, you may or may not have heard of this phrase, but this essentially is referring to the fact that, between as I said, the buyer and supplier have their own terms and conditions. So the question is, whose terms and conditions will be used in your transaction? Now, what you have to appreciate is that over the course of interacting with the supplier, your terms and conditions will be exchanged a number of times. So for example, when you send out your request for quotation, you will send the request for quotation, the specification, alongside your terms and conditions, and essentially say, look, this request for quotation is in accordance with our terms and conditions. Fair enough. The supplier, on the other hand, when they submit their quote, and at the bottom it says this quote is subject to the supplier's terms and conditions, right? So essentially you've got a counter offer back from the supplier saying, no, we don't want to accept your terms and conditions. We're going to use our terms and conditions. And this back and forth goes on because when you send out the purchase order, attached to the purchase order will be your terms and conditions. When the supplier sends you back an acknowledgement letter, they will attach their terms and conditions. So you get this back and forth of terms and conditions. Now, the general rule of thumb is that the last shot fired. So the last the party that sends their terms and conditions over to the other party without getting back anything in return, it is those terms and conditions will be used. So potentially when the supplier sends over the invoice, and on the invoice it says, please pay X amount subject to our terms and conditions, that's potentially the last communication and the last transfer of terms and conditions. So you could argue that, a lot of contracts will be judged on the terms and conditions of the supplier. So it's very important for us to look out for that as clients, because there will be differences between our terms and conditions and the supplier's terms and conditions. For example, payment terms. We may have 30-day payment terms in our terms and conditions. The supplier may have 10-day payment terms or next day payment terms and conditions. So it's very important that we ensure that our terms and conditions are the ones which are going to govern the contract itself. Another way around this is to have a framework agreement. And I'll talk about that in another webinar, but essentially a framework agreement allows you to carry out routine transactions under a pre-agreed set of terms and conditions. So that's another option that could be done to avoid the battle of the forms and falling into the possibility of you having to use their terms and conditions to govern the contract. There is an example. There was a case between Transformers and Rectifiers Limited and Needs Limited. And these were two parties that did business for over, or had a business relationship for over 20 years. Needs Limited supplied a number of components to Transformers and Rectifiers. And what transpired, it got to a case where there was a dispute over whose terms and conditions will be used. And when it went to court, it was found that when the buyer, Transformer and Rectifier, sent over their purchase order, the terms and conditions were on the other side of the paper, right? But because the document was faxed over to the other party or sent via email to Needs Limited, they did not copy the other side which had the terms and conditions. So all Needs Limited received was a one-sided piece of paper that had the purchase order on it without the terms and conditions. On the other hand, when Needs Limited sent an acknowledgement form to say, yeah, we've got the purchase order and we're happy to go ahead, on their acknowledgement form, they stated that terms and conditions could be, they stated that this, the contract would be on their terms and conditions. And if the buyer wanted to find out about the terms and conditions, they could, upon request, they would be supplied with the terms and conditions. So the acknowledgement did not contain the terms and conditions. So when they, went to court, the court found that neither party could enforce their terms and conditions, because in order to enforce your terms and conditions, you must draw the attention of the other party to your terms and conditions. So when the buyer, Transformer and Rectifier sent over their purchase order, but didn't, copy the back, they did not draw to the attention that there were actually terms and conditions on the other side, because all, Needs Limited got was the one side of purchase order. And in return, Needs Limited, when they sent over their acknowledgement letter, they didn't also send across the terms and conditions. All they did was say, look, upon request, you can get a copy of the terms and conditions. So the judge said that, look, because both parties, neither of you drew the attention of your terms and conditions to each other, neither of your terms will apply to the contract. So, the moral here is to say, if you're going to, send over your terms and conditions, make sure you draw the attention of your terms and conditions to the other party. All right, so you specifically state the terms and conditions are on the next page and make sure they're able to read that. And on that basis, your terms and conditions can be accepted. In terms of most common commercial disputes, most common one is non-payment of goods and services. So I think the first thing to think about when you're in that situation as a business is to think, okay, well, what does it say in the contract? Now, some contracts may have a non-payment clause, which states what will happen in the event there's a non-payment. So it may say, for example, that, in the event of non-payment, for every day the payment is late, there will be a charge. The late payment will attract an interest charge of a certain percentage. And that will definitely draw the attention of the other party, the good thing about having a clause like that is it would draw the attention of the other party to say, look, we can't afford to not pay on time because we're going to actually be paying additional interest if we don't pay on time. So, that's a good thing about having a clause in place. However, if there isn't a clause, it's always a good idea to get in contact with the client or get in contact with the client to find out why there's been no payment. It could just be a simple oversight. And in that case, it's likely it could be rectified quite quickly and easily. It could be that the business is having some difficulties and they want a bit more time, which, depending on your own financial situation, could be acceptable or not. But I think that the key thing or the key reason to get in touch with the other party first and not to jump to any legal remedies is, the best way to settle any dispute is through dialogue with the other party and reaching an agreed settlement with the other party, as opposed to having to go to court. Because as I'll talk about later, court attracts a lot of cost and takes up a lot of time as well. So by getting in touch with the client to find out the reason for the non-payment and how the payment could be settled at a later date is the best solution to rectifying a problem around non-payment. Another clause that you may want to have, or that may be there, particularly with goods, is a retention of title clause. The retention of title clause may say that, look, the goods, the ownership of those goods will only pass hands once final payment has been made. So if the client hasn't made final payment, as far as the contract is concerned, you still own the goods, even if it's in the client's possession. So therefore, you have a right to obviously take it back. So that could be a clause as well that would give strength to your position in the event of non-payment. There are other options in terms of suspension of service. By the way, you can't have a retention of title with a service. It's quite difficult to have that because ownership doesn't change hands with services, unlike with physical products. You can also potentially suspend your service. And again, that's taking it, that potentially means you haven't been able to settle amicably through dialogue. And as a result, you may decide to withhold your service. And that too is also open to you in the event of non-payment. Another area of dispute is when goods or services are below quality or of different, different to what's been agreed. I think the key thing to remember in the UK, there is the Consumer Rights Act, and the Consumer Rights Act states that goods sold must be fit for purpose. And if they're not fit for purpose, regardless of what it says in the contract, even if there's no mention about the goods having to be fit for purpose in the contract, it is the law that it must be fit for purpose, and therefore you have rights to reject the goods if they are not fit for purpose. Under this act, it also says that goods sold must meet the description under which they're sold. And again, if the goods don't meet the description they're sold upon, regardless of what it says in the contract, the law states that goods must be sold under the description they're sold, and on that basis, you would have rights to return the goods. Also, potentially, you could have a warranty clause to ensure that, if within a year, 2-3 years, something happens to the piece of machinery or, the product, you can return it or have it replaced at no cost to yourself. So that's another way to remedy poor product or service without any cost. And again, having a non-performance clause will provide clarity. I think the biggest benefit of having such clauses in your contract is that it removes the uncertainty about what will happen when there's poor quality. So a non-performance clause may state, for example, that in the event goods are unsatisfactory, the goods will be, it is our right, the client, for example, it's the client's right to determine whether a good is satisfactory or not, and upon that basis, it will be rejected. So therefore, in the event a good is not satisfactory, it clearly states in the contract that you have the right to reject it because it doesn't meet the specifications, and there's no gray area. The supplier can't say, no, we're not taking it back, because they've signed up to the fact that they will have to take it back or it will be returned if it doesn't meet the specifications. Misrepresentation. Misrepresentation is another area where potentially there could be disputes. And misrepresentation essentially means where a seller knowingly makes a false statement, a factually false statement, for which that statement induces the buyer to actually go ahead and buy the product or service. This big example about this came up with, allegedly, I should say, came up with Volkswagen. And Dieselgate. You may or may not have heard about that, but Volkswagen was selling diesel cars, and they were selling these cars. They were selling these diesel cars, stating that these cars had very low emissions. And the reason they said it had low emissions was because when the cars went for their environmental tests, Volkswagen had fitted in a device, if you like, a cheat device, which reduced the emissions. So when the testing was underway, it seemed as though the car was giving low emissions. But after the testing, they took the device out and it was back up to producing relatively high emissions. So VW, as part of their marketing campaign to sell these cars, went out and said, look, our cars are being tested and they have low emissions. And they were passing that off as fact. They were saying, look, factually, a test has been done, and it hasn't met the it's low emissions. And on the back of that, a lot of customers bought the cars ahead of other cars which potentially had higher emissions. The result has been that VW has had to pay out about 30 billion to customers and fines and compensation, because customers essentially, once they found out that actually the cars they were driving had a lot higher emissions, said, no, we don't want this car anymore, give us our money back, because we were under the impression that it had low emissions. So that allegedly or potentially is an example of misrepresentation. Another clause to think about is that of a confidentiality clause. And there was where you have commercially sensitive information, in the course of your transaction with the supplier, you may need to divulge that information to the supplier. So it's important that you have some kind of confidentiality clause which protects or restricts the other party from sharing that information to other third parties. However, the information that you're asking the other party to be confidential about cannot be public knowledge. And there was a case between Amex or American Express and Mrs. Puri. And Mrs. Puri used to work for American Express and gained a lot of information while working for American Express. And subsequent to that, she went on to work for a competitor of American Express. And American Express took her to court to say, look, since working for this competitor of ours, you have used information that you gained from us to your advantage at your new firm. And she replied, and she had signed a confidentiality clause with American Express. So they were enforcing that confidentiality clause. But Ms. Puri said that, look, the information I'm using with this new firm I'm working for is actually public knowledge. So, it's not a case of me keeping it confidential. Other people, anybody could have accessed that information since it's public. And the court found in our favor. The court said, yes, we agree that it was public knowledge, and therefore the confidentiality clause did not apply. So I think the thing here to make sure is that if we're going to use a confidentiality clause, we have to, be certain that the information we are trying to protect is not public knowledge, and has a competitive advantage from your point of view. Another clause that you may have is a dispute resolution clause. And again, the whole purpose of having a dispute resolution clause is to add certainty as to what happens in the event there is a dispute. Now, if you don't have a dispute resolution clause, then anything can happen, or the dispute can go in a whole bunch of different directions, because there's nothing in the contract that says what should happen when there's a dispute. So that's the reason for having a dispute resolution clause. And essentially such a clause will have, if you like, stages, upon which if you cannot agree or settle the dispute at one stage, you move to the next stage. So in the event of a dispute resolution clause would state words to the effect of, the first thing to do in the event of a dispute for both parties is to escalate the dispute. So, you escalate the matter, or you escalate the dispute to management. Now, management, bearing in mind they may have a more bigger picture view of the relationship between the buyer and the supplier, they may think it necessary to negotiate and agree a settlement. Yeah, and at that stage, the escalation and negotiation resolves the dispute. However, if the dispute is not resolved, then it goes, you go to mediation and arbitration. Now, again, you may have heard of that before, but mediation and arbitration involve an independent third party. And the difference between a mediator and an arbiter is that a mediator, has the purpose of facilitating a settlement between two parties. But the mediator won't take sides, or it won't give judgment on who's right, who's wrong between the two parties. You could imagine a situation where the two parties, the buyer and supplier, are, there's an acrimonious atmosphere and neither party wants to talk to each other. A mediator can provide that independence, that neutrality that can bring the two parties together to meet. And the mediator will also point out the areas that need to be discussed in order for the resolution or the settlement to happen. Right. But the key thing with the mediators, they won't pass judgment. They are purely there to facilitate the dialogue between the two parties and point out areas that they think is relevant to reach a dispute, to reach a settlement. You also have arbitration. The difference between mediation and arbitration, again, they're both third parties, independent, but an arbiter has the power to force one party to attend if they're reluctant to attend an arbitration session. An arbiter as well will also give judgment. Now, you can have non-binding judgments or you can have binding judgments. If it's a non-binding judgment, then the party that is not happy with the judgment can take it to court. But if you have a binding judgment, then it's binding on both parties, whatever the judgment is from the arbiter. I think another thing to say with mediators and arbiters is that in the contract itself, it's probably a good idea to state who the mediator is or who the arbiter is, so that when you get to that stage, there's no sort of arguments about who the mediator or arbiter should be. Another way of doing it is to say, when it comes to deciding a mediator, both parties need to agree on whichever mediator is agreed upon. But either way, you don't want another dispute over who the mediator is or who the arbiter is upon the dispute you already have. So it's probably good to have some clarity in the contract to say who the mediator and the arbiter will be in the event that you get to that stage. And the final stage is litigation, going to court. As we probably all know, going to court is extremely expensive from a legal fees perspective. I think as well, more often than not, it potentially means the end of the relationship between the buyer and supplier. And also as well, I think another thing that maybe people are not aware of is the fact that going to court potentially means everything comes out in the open. And, such confidential dealings, you may not want them to go out in the open, but once it gets to court, then it's open. And I guess that's another advantage, why you would want to go to arbitration ahead of litigation, because arbitration, the matter or the details of the case can be done privately. So yeah, that's the dispute resolution clause, and the whole purpose of the dispute resolution clause is to provide some certainty about what to do in the event there is a dispute, so that it at least gives you one less thing to worry about, and you can focus on trying to manage the dispute. So far what we've talked about is the fact that by including clauses, either it's a non-payment clause or a performance clause or a confidentiality clause or a dispute resolution clause, ultimately what we're trying to do is think about what could happen, and based on what we think could happen, we then come up with a clause that will guide us on how to deal with that event when it happens. Right. So that's what a good contract is. A good contract tries to identify the possible risks in a transaction or relationship, and it tries to mitigate that, or it tries to say what will happen or how will it be resolved if it does happen. And if you have something in the contract which helps resolve a problem, it saves you having to go to court. Most times you go to court because there isn't anything in the contract to say what should happen. And ultimately, you're going to leave it up to the judge to decide what should happen. So I guess the question then is, can you actually cover all eventualities? Can you always foresee everything that's going to happen and building clauses into a contract? And a good example of how potentially you can't is the global pandemic. I mean, no one really saw that coming. So there's an example here with insurance companies or business insurance. There was a particular type of cover called the business interruption insurance cover for small businesses. And, the purpose of this cover was to provide businesses who, for example, experienced a power cut, or maybe there was a flash flood in their local area, and would mean, the business would have to pause for a couple of days whilst the flood cleared or the power came back on. So this insurance cover provided for those couple of days, or, financial compensation for those couple of days lost due to a power cut or, a flood. Having said that, the next thing was we had a pandemic, and, businesses we all went through lockdown, and businesses were closed for 3-4 months, depending on what country you're in. And, these businesses said to their insurance company, look, we've got business interruption insurance cover. Our business has been interrupted for 3-4 months, therefore pay out. And the insurance companies turned around and said, well, actually, when we provided this business interruption cover, we never anticipated there'll be such a thing called a lockdown where businesses will be shut down for 3-4 months. The whole purpose of business interruption cover was to just tide you over or provide some financial compensation for a couple of days. And since, this pandemic has been for 4 months, we are not paying out to cover you for 4 months loss of business. So potentially, what happened was there was a standoff. The insurance company didn't want to pay out. The small businesses said, look, we had this cover, our business has been interrupted, so pay out. Ultimately, it went to the Supreme Court in the UK, and the court found that insurers should make payments totaling 1.2 billion. So they, in the end, had to pay out because they did not, in the insurance cover, they did not expressly state that this business interruption insurance cover does not cover pandemics. Now, obviously, 2-3 years ago, no one even had heard of a pandemic, or may have heard of it, but never actually thought it could happen. So it was, it's quite difficult to put that into a contract or insurance cover when you can't anticipate it. Having said that, Wimbledon, the tennis tournament, they took out pandemic cover. I think from their experience of SARS, which happened, I think in the early 2000s, they decided to take out, 10-15 years ago, took out pandemic cover. So they got a nice big payout of, I think, 120 odd million pounds when they could not hold the Wimbledon tennis tournament, because they specifically did cover that eventuality and did have pandemic insurance cover. So yeah, some people do think of everything. So ultimately, we're talking about, thinking of everything to cover in a contract, but through partnerships between buyer and supplier, or between two businesses, potentially you can reduce the need for a contract, because ultimately a contract provides a remedy. It provides us with what to do in the event there's a problem. But if your partnership is so strong that any problem that comes about, you will agree upon yourselves because of the partnership and settle it yourselves, then you could argue there's actually no need for a contract. So, for example, with your family members, right? You may have disagreements with your family members, but because you are family, you will always resolve that in some shape or form, because you're family, you have that binding connection. So I think with partnerships, if you can find that binding connection, potentially you don't need a contract to refer to, because that binding connection will always help you resolve any matters that arise in your relationship. And a good example of this is Coca-Cola and McDonald's. They partnered together as far back as 1955 because they shared an ambition. They shared an American expansion ambition. Both Coca-Cola and McDonald's wanted to expand across America and globally. And not only that, their products complement each other. Some might argue that you can't have a Big Mac without a Coke or a Fanta or vice versa. So, you know, not only do their products complement each other, but they also share the same vision. And believe it or not, Coca-Cola and McDonald's do not have a contract written on paper. But up till today, they have a very strong partnership. Now, I'm not privy to it, but they must have had disagreements between themselves over the last 60 plus years. But that partnership is strong enough to resolve it without having to refer to a contract. And even recently, you may have seen they both agreed at the same time to pull out of Russia. And again, you would imagine there was some, sharing of information and discussion about whether they should pull out, and they did it together. So ultimately, what you want to try and find in your contracts is the ability to build trust, the ability to have a shared objective, because having trust, shared objective, open communication between yourselves allows you to ride through any disputes without having to look at the contract, without having to go to court. So when thinking about suppliers you do business with, particularly for a relatively larger expenditure, one of the key criteria you should look at is, well, who are the people on the vendor side that we're going to be interacting with on a daily basis? Can we build relationships with them? Do we have shared objectives? If you do, then and you could find that out through getting their CV, understanding their own the personnel from the supplier, understanding their own backgrounds and understanding their own characters. And if you do find that, when you do have disputes, that relationship is a very powerful support to be able to see out or to settle any disputes without having to refer to contracts or going through any litigation or mediation, arbitration, and so on. So I think whilst contracts, we must look for all the eventualities to minimize the risk and cover all those clauses in the contract, such as non-payment terms, non-performance terms, confidentiality clauses, dispute resolution clauses, force majeure clauses, and so on. I think equally important is our relationship with our suppliers and their relationship with us, because that can save us a lot of cost, a lot of time wasted, because we share the same goals, we're committed to working together, we trust each other, and therefore it's more likely that we'll reach an amicable settlement than having to go through courts or anything like that. Right, so that is it. Thank you very much for listening. My name is Kala. Please feel free to get in touch. My email address is kaladikibo@telso.co.uk. I'll be happy to answer any specific questions that you may have in this area or in any other area for that matter. So thank you very much.